Okay, Earl Appeal Part 2, starting at number 2. The trial court erred in admitting the extraneous offence evidence in violation of Texas Rule of Evidence 403. The trial court erred in admitting the extraneous offence evidence, brackets discussed in Section 1, supra and incorporated herein for purposes of brevity, brackets, in violation of Texas Rule of Evidence 403, as the probative value of the evidence was substantially outweighed by the danger of unfair prejudice. Generally, Rule 403 favours the admission of relevant evidence and carries a presumption that relevant evidence will be more probative than prejudicial. There's some references. When considering a Rule 403 objection, courts must balance 1. The inherent probative force of the proffered item of evidence, along with 2. The proponent's need for that evidence against 3. Any tendency of the evidence to suggest a decision on an improper basis 4. Any tendency of the evidence to confuse or distract the jury from the main issues 5. Any tendency of the evidence to be given undue weight by a jury that has not been equipped to evaluate the probative force of the evidence, and 6. The likelihood that presentation of the evidence will consume an inordinate amount of time or merely repeat evidence already admitted. Then other references. In practice, these factors may blend together. Trial courts have broad discretion in conducting a Rule 403 balancing test, and reviewing courts will not lightly disturb the trial court's decision. Rather, it is only when there exists a clear disparity between the degree of prejudice of the offered evidence and its probative value that the evidence is considered unfairly prejudicial in violation of Rule 403. Another reference. An application of the pertinent factors in this case warrants reversal, as there is a clear disparity between the degree of prejudice and the probative value of the extraneous evidence. First, the probative force of the extraneous evidence was to be for rebutting the assertions made in defence counsel's opening statement that B.W.'s story was not credible because it was an allegation that seemed impossible, to have been sexually assaulted every night for 2 years in a small trailer with 7 other people, and no one saw or heard anything. As discussed in Section 1, supra, the presented extraneous evidence did nothing to further that rebutting trial counsel's claim, but rather was merely propensity evidence. What about defence counsel's impossibility and thus lack of credibility? Claim is rebutted by extraneous allegations that were alleged to have occurred openly in front of others, or by evidence that in 3 or 4 years a person walked inside a restroom 2 or 3 times and then immediately turned around and walked out and said, "I'm sorry," or touching of a person's leg mid-thigh with no allegation of sexual misconduct ever being alleged by that person, brackets JW. The propensity value of the extraneous evidence was 0, and if not 0, marginal. The evidence did not bolster B.W.'s credibility or refute an impossibility argument. Rather, it merely diminished Worden. The damage was huge. Texas courts recognise that extraneous offence evidence of this nature does tend to suggest a verdict on an improper basis because of the inherently inflammatory and prejudicial nature of the crimes of a sexual nature perpetrated against children. And this is the context in which the state presented these alleged bad acts at trial and in their closing statements. Additionally, the state did not need the extraneous offence evidence in order to present the entirety of their case against Worden. B.W.'s story and its inconsistencies and contradictions contain the allegations for which Worden was on trial. The extraneous offence evidence did not go to any elements of the charged offence, or as discussed above, to rebutting issues brought up by defence counsel. Instead, the extraneous matters confused and distracted the jury from the main issues at trial. An inordinate amount of time was spent on these extraneous allegations, which were presented through 2 of the state's 5 witnesses, and which comprised half of the second day of testimony before the jury, and which was the focus of a significant amount of the state's closing arguments. Finally, as discussed in Section 1, brackets harm section, and incorporated herein, Worden was harmed by the introduction of this testimony, which had a substantial and injurious effect or influence in determining the jury's verdict. As B.W.'s allegations were weak, inconsistent, and contradicted, and unsupported by any corroborating evidence, only propensity evidence was offered in support, and the other inadmissible evidentiary items presented herein. Worden requests that this court find that the trial court erred by admitting the admission of the alleged extraneous bad acts and that Warden was harmed as a result. Warden requests this court grant relief on this claim, find that his substantial rights were violated, and grant him any and all further relief to which he may be entitled, including vacating his conviction and remanding for a new trial. 3. Trial counsel's opening the door to prejudicial extraneous offence evidence constituted ineffective assistance of counsel. Trial counsel's opening of the door to the prejudicial extraneous offence evidence discussed in section 1 to 3 and incorporated herein for the purpose of brevity constituted ineffective assistance of counsel under the Sixth Amendment to the US Constitution and was not part of his trial strategy, as trial counsel himself recognised. The Sixth Amendment to the US Constitution, made applicable to Texas through the 14th Amendment, provides that in all criminal prosecutions the accused shall enjoy the assistance of counsel for his defence. This Sixth Amendment provision provides more than just the presence of counsel alongside the accused, but rather provides for the right to the effective assistance of counsel, envisioning counsel playing a role that is critical to the ability of the adversarial system to produce just results. Reference: Strickland standard for assessing IAC claims. To prevail on a claim of ineffective assistance of counsel requiring reversal of a conviction, an applicant must establish by a preponderance of evidence that 1. Trial counsel's performance was deficient, and 2. That this deficient performance deprived the applicant of a fair trial. Another reference. Under the first prong of Strickland, the applicant must show that trial counsel's performance fell below an objective standard of reasonableness. Stated differently, the applicant must show by a preponderance of the evidence that trial counsel's actions did not meet the objective norms for professional conduct. Another reference. Under the second prong of Strickland, the applicant must show that the deficient performance prejudiced the defence. Restated, this requires establishing that there is a reasonable probability that, but for the trial counsel's deficient performance, the outcome of the proceeding would have been different. A reasonable probability is that which is sufficient to undermine confidence in the outcome. When evaluating a claim of ineffective assistance, courts consider the totality of the representation and the particular circumstances of the case. Another reference. There is a strong presumption that trial counsel's actions and decisions were reasonably professional and were motivated by sound trial strategy. Deficient performance. Extraneous offences are inherently prejudicial, and when counsel fails to object to numerous extraneous and prejudicial matters or opens the door to such evidence where it is not part of a legitimate strategic or tactical decision, counsel is ineffective. Another reference, which, finding no reasonable explanation for why defence counsel would open the door to damaging extraneous evidence. The trial court determined that trial counsel's opening statement where it attacked BW's credibility by stating that her claimed story of abuse was not possible to have occurred 600 times in a small trailer with 7 other people present without seeing anything, opened the door to the 4 extraneous bad acts offered through BW and JW. It constituted deficient performance to open the door to such extraneous matters by directly attacking BW's credibility, when the credibility and the sheer impossibility of that inconsistent and contradicted story would be before the jury without his unnecessary and direct opening the door commentary. It was not a part of sound trial strategy to have opened the door to the extraneous evidence, and defence counsel himself recognised during the hearing on whether the door had been opened that it was never a part of his trial strategy to do so, stating, "I've not intended to open the door to the extent that I have, and it's harmful to my client. I'll admit that later, I just want to be clear." The state similarly acknowledged we were reassured several times by defence counsel that he would not be opening the door. This was consistent with defence counsel's statement just before the jury selection. "I'll put on the record, I doubt we're going to be opening the door of anything, and I don't intend to." Warden requests this court find his counsel's performance was deficient for opening the door to the alleged extraneous bad acts. Prejudice. Warden was prejudiced by his trial counsel's deficient performance, which led to the admission of the alleged extraneous bad acts and which were otherwise inadmissible. Extraneous offence evidence is inherently prejudicial. Reference. and the extraneous offence evidence offered in this case was inherently inflammatory and prejudicial, as the state presented it to suggest bad acts of a sexual nature perpetrated against his children. As discussed in Section 1, harm section, supra, and incorporated herein for the purposes of brevity, Warden was damaged by the introduction of this testimony, which had a substantial and injurious effect or influence in determining the jury's verdict, as BW's allegations were weak, inconsistent, directly contradicted, and unsupported by any corroborating evidence, and where only propensity evidence was offered to support her claims, and the other inadmissible evidentiary items presented herein. Additionally, the state theories and arguments rested heavily on the alleged extraneous acts, and the state relied upon them heavily in its trial evidentiary presentation and closing arguments. Trial counsel's deficient performance prejudiced Warden as a confidence in this verdict was undermined, and there is a reasonable probability that the results of this proceeding would have been different but for that deficient performance that allowed the trial to be injected with highly inflammatory and damaging character evidence offered to demonstrate that Warden was morally reprehensible. Warden requests this court find that he was deprived of his rights to the effective assistance of counsel under the Sixth Amendment to the U.S. Constitution, applicable to the state through the 14th Amendment, and grant him all relief to which he may be entitled, including vacating his conviction and remanding for a new trial. 4. The trial court erred in admitting the improper opinion testimony of Detective Reed, a child sex abuse investigator and expert who opined the complainant was credible. The trial court erred in admitting the improper opinion testimony of Detective Reed, a trained child sex abuse investigator and expert, who opined directly over trial counsel's objection that the complainant in this case was credible. Texas law is well established that Rule 702 of the Texas Rules of Evidence does not permit an expert to give an opinion that the complainant or class of person to which the complainant belongs is truthful. There's some references stating that experts on child sexual abuse are not human lie detectors. In Yount, the Texas Court of Criminal Appeals reaffirmed that such expert testimony does more than assist the trier of fact to understand the evidence or to determine a fact and issue, but rather it decides an issue for the jury. Reference. Despite the prohibition of this type of testimony, the trial court allowed Detective Reed to directly testify that he found BW credible based on her emotions and reactions through his interviews. Warden was harmed by this error, which affected his substantial rights. The state was able to present a direct comment on BW's truthfulness from a trained expert who specialises in child sex abuse cases and investigations, and has done hundreds of these investigations, and who found her allegation credible based on a subset of specific criteria, her emotions and reactions in his interview. Moreover, as discussed in Section 1, harm section, and incorporated herein, Warden was harmed by the introduction of this testimony, which had a substantial and injurious effect or influence in determining the jury's verdict, as BW's allegations were weak, inconsistent, and directly contradicted and unsupported by any corroborating evidence, and where only propensity evidence was offered in support. Warden requests that this court find that the trial court erred by admitting the truthfulness testimony of Detective Reed over trial counsel's objection, and that Warden was harmed. Warden requests this court grant relief on this claim, find that his substantial rights were violated, and grant him any and all further relief to which he may be entitled, including vacating his conviction and remanding for a new trial. 5. The repeated outside influences brought to bear on the jury and juror misconduct violated Warden's right to a jury trial. Warden was deprived of his 6th and 14th Amendment right to a fair and impartial jury, free from outside influences, where numerous outside influences were brought to bear on the jury, also serving to constitute juror misconduct. The 6th Amendment to the U.S. Constitution provides that, in all criminal prosecutions, the accused shall enjoy the right to an impartial jury. In conjunction with the 4th Amendment's Due Process Clause, this right guarantees an individual the right to a fair and impartial jury that is free from outside influence. Texas law is well established that outside influences must not be brought to bear on any juror. In order to be entitled to relief based on outside influence or juror misconduct, the defence must establish that an outside influence was improperly brought to bear on any juror. An outside influence is something originating from a source outside of the jury room and other than from the jurors themselves. Then, without delving into the jury's deliberation, the trial court must an objective analysis to determine whether there is a reasonable probability that the outside influence had a prejudicial effect on the hypothetical average juror. Worden meets this standard. As discussed in Statement of Facts, section D-1, and incorporated herein, numerous outside influences plagued Worden's trial and were brought to bear on the jury, including an attendee perceived to be associated with Worden, following jurors to their cars, communication and attempts to communicate with jurors by attendees openly against Worden, attendees shouting that Worden was a rapist and sex offender within earshot of the jury, the trial court's mid-deliberation comments that they had heard about 25 years of this dysfunctional family in just 2 days, and the trial court's emphasis that there was a lot of crazy stuff on the internet about Worden if the jurors were to Google him. These outside influences were impermissible, originated from outside the jury room, and were not a result of the actions of jurors themselves. An objective analysis of these events establishes a reasonable probability that these outside influences would have a prejudicial effect on the hypothetical average juror. Jurors being followed to their cars by a trial attendee, walking behind them, amidst them, and carrying cameras and filming equipment raises serious concerns about safety, privacy, and security for any juror, particularly when the attendee has been perceived as being associated with Worden. Such concerns inevitably become aimed Worden's way, as the trial court itself made clear when it told Worden that his friends had not done him any favours. Worden ultimately became seen as being accountable for Gray's individual and unacceptable conduct. Attendees actively against Worden speaking to jurors outside the courthouse in a minute-long conversation that was more than just casual passing would also have a prejudicial effect on the average hypothetical jurors. These attendees were not there to help Worden receive a fair trial. One attendee was ordered out of the courtroom after speaking to a veneer panel member during voir dire, and the attendee seen speaking to jurors was also in the hallway outside the courtroom shouting that Worden was a rapist and sex offender within earshot of the jury, to such an extent that bailiff came outside to address the issue. The trial court's commentary on the evidence during deliberations about the jury having heard about 25 years of this dysfunctional family in 2 days of testimony would also have a prejudicial effect on the average hypothetical juror. Naturally, the court's role in our system of justice puts it at the centre of the entire process. The jury, and even the lawyers, look to the court as the authority on everything that takes place inside the courtrooms. A trial court's mid-deliberation commentary that the jury saw 25 years of this dysfunctional family, particularly right before the jury went home for the day, makes any rational person wonder what caused all this dysfunction the court just mentioned, sexual abuse. It also highlights and magnifies the state's presented case, including BW's testimony. This commentary, prejudicing Worden, came from the most authoritative source in the entire process, the court. The court's emphasis that there was crazy stuff on the internet about Worden also served as an outside influence that would affect the average hypothetical juror. It is understood that the court has the responsibility and duty to ensure that the jurors not seek outside or consult outside information, but that responsibility and duty cannot extend to creating impressions about what would be found if they were to look, or to present that such information would be found in what would be an appealing way. Moreover, the follow-up events make clear that the jurors were impacted by these issues. As an initial matter, at the end of the first day of trial, the jurors reported that they were evenly split, and half the jurors indicated that additional deliberation time would do no good. The jurors then adjourned for the day and returned. Jurors reported to the court that they had been followed to their cars by Gray. Additionally, the jury's final note raising concerns about audience members and the jurors' privacy concerns considering the audience members shows that these jurors were impacted by these outside influences, the same as any hypothetical average juror would be. Warden requests that this court find that the outside influences constituting juror misconduct violated Warden's right to a fair and impartial jury trial, free from outside influence under the 6th and 14th Amendments to the US Constitution, vacate his conviction and give him all further relief to which he may be entitled. 6. The trial court erred in denying Warden's motion for a new trial, as the court improperly considered juror deliberations when analysing the outside influence and juror's misconduct claim. The trial court abused its discretion and erred in denying Warden's motion for new trial based on his presented outside influence and juror misconduct claim, the same claim presented in Section 5, as the trial court improperly considered the juror's deliberations in evaluating and assessing his claim. Following the trial court went into the jury room and observed the jurors' work product, observing that they had papered the room with giant pieces of white paper, different colours, charts, diagrams, a list of witnesses and dates to show the diligence they did over multiple hours of deliberation. The trial court made these observations as part of its rationale for denying Warden's motion. The consideration of evidence of the juror's deliberation in evaluating the claim is prohibited by Texas Rules Evidence 606(b) and by the well-established case law that requires that the reviewing court conduct an objective analysis to determine whether there is a reasonable probability that the outside influence had a prejudicial effect on the hypothetical average juror, without delving into the jury deliberations. Reference. The trial court erred in the analysis of Warden's presented claim. Should this court not grant Warden's request for relief for his presented outside influence and juror misconduct claim presented in Section 5, Warden requests that this court find that the trial court erred in its analysis of Warden's motion for new trial on that presented ground and remand the claim to the trial court for consideration under the proper standard. Warden requests this court grant him all further relief to which he may be entitled. 7. The trial court's remark and improper opinion that jurors heard about 25 years of a dysfunctional family at best violated Texas Code Criminal Procedure Article 3805. The trial court's remark and improper opinion before the jurors that they had heard about 25 years of a dysfunctional family at best during the middle of deliberations violated Texas Code of Criminal Procedure Article 38.05. That article provides that the trial court shall not at any stage of the proceeding previous to the return of the verdict make any remark calculated to convey to the jury his opinion on the case. This article places a duty on the trial court which cannot be waived even by defendant's failure to object, not to make any comment regarding his opinion of the case. Reference. The Texas Court of Criminal Appeals has recognized that this statute reflects a devotion within the Texas adversarial system that the judge is neutral arbiter between the advocates, and has recognized that jurors are prone to seize with alacrity upon any conduct or language of the trial judge. Reference. As discussed in Section 5 and 7, the trial court's commentary on the evidence during deliberation about the jury having heard about 25 years of this dysfunctional family in 2 days of testimony harmed Warden. The trial court's mid-deliberation commentary that the jury saw 25 years of this dysfunctional family, particularly right before the jury went home for the day and while the jury was split 6-6, makes any rational juror wonder what caused all this dysfunction the court just mentioned, sexual abuse, ? Additionally, this commentary both showcased and highlighted the state's presentation of evidence through BW, JW, J and SW, and the charged offence and the alleged extraneous acts, all of which contested and by Warden in his defence of the case. Ultimately, the court's commentary was a ratification of the idea that there was 2.5 decades worth of dysfunction within that family. And who was the head of family? Warden. The commentary regarding 25 years of family dysfunction also harmed Warden because the most readily available explanation from the trial regarding any alleged familiar dysfunction were BW's allegations and the alleged extraneous acts regarding JW. This commentary thus added to the credibility of the claims made against Warden and effectively constituted victim impact commentary, as discussed at length in Section 1 (harm) section and incorporated herein for the purposes of brevity. Though BW's testimony was contradicted, inconsistent and unsupported by any corroborative evidence, the trial court's commentary highlights that the defence did not, and had no legal burden to provide any explanation as to the cause of the purported 25 years of this dysfunctional family, which should not have been assumed true. Warden requests that this court find that the trial court's commentary was in violation of Article 38.05 and that Warden was harmed as a result of that commentary. Warden requests this court grant relief, vacate his conviction and remand this case for a new trial. 8. The trial court's remark and improper opinion that jurors have heard about 25 years of a dysfunctional family at best violated Warden's right to due process. In Proenza, the Texas Court of Criminal Appeals recognised that a judge's commentary on the evidence could rise beyond merely violating the statutory prohibition created under Article 38.05 of the Texas Code of Criminal Procedure, but at some point, however, a trial judge's comments can violate a defendant's constitutional due process rights. References. For purposes of brevity, Warden incorporates argument made in Section 7 and submits that the trial court's remark and improper opinion before the jurors that they had heard about 25 years of a dysfunctional family at best during the middle of deliberations also violated Warden's right to due process of law under the 5th and 14th Amendments to the U.S. Constitution. As discussed at length in Section 7, that commentary harmed Warden, highlighted the state's evidence, including the testimony of B.W., S.W., J.W., and J., ratified the idea that there was dysfunction within the family that had lasted for 2.5 decades and effectively placed the blame for the dysfunction on Warden because he was the head of the family and because the defence did not provide any explanation for the alleged family dysfunction. Naturally, any rational juror hearing the trial court's improper commentary would wonder what caused all this dysfunction the court just mentioned. Sexual abuse? The commentary added to the credibility of the claims made against Warden and were effectively victim impact commentary. Because of the magnitude and far damaging consequences of the trial court's comment, Warden requests that this court find that the trial court's commentary was in violation of the due process clauses of the 5th and 14th Amendments, and that Warden was harmed as a result of that commentary, and that it cannot be determined beyond a reasonable doubt that the error did not contribute to the conviction. Warden requests this court grant relief, vacate his conviction, and remand this case for a new trial. 9. The state's injection of racial and religious animus and stereotyping into the trial violated the 1st and 14th Amendments to the U.S. Constitution. The state's injection of racial and religious animus and stereotyping into Warden's trial, claiming that he refused to associate and live with his wife who was pregnant with a black child, and that he was a Mormon seeking to get his daughter to convert to Mormonism so he could marry her, violated the 1st and 14th Amendments to the U.S. Constitution. The Supreme Court has long recognized the 1st and 14th Amendments to the U.S. Constitution generally preclude the use of an individual's associations and beliefs at trial, where those associations and beliefs are not relevant to the issues involved in the case. Reference. The First Amendment protects an individual's right to associate or non-association with others, and penalising an individual based on his First Amendment exercises, where the evidence is not relevant to issues at trial, is nothing more than penalising him for his abstract beliefs and is employed simply because the jury would find these beliefs morally reprehensible. The Texas Court of Criminal Appeals has recognised Dawson as extending to First Amendment freedoms of religion and to the guilt-innocence phase of trial. There's reference. The state injected Warden's trial with an irrelevant allegation that he harboured racial animus towards others, specifically a black child, on account of the child's race. The state introduced this evidence merely for the purpose of attacking and penalising Warden based on the false idea he had a belief system that involved him not wanting to associate with black individuals, protected conduct under the First Amendment to the U.S. Constitution. The state also presented that Warden was a Mormon and attempted to get the complainant to convert to Mormonism, doing so because it would be acceptable in the Mormon Church to marry one's own children. The presentation of such evidence is nothing more than injecting religious stereotyping and animus repugnant to the First and 14th Amendments into the trial. An individual has a First Amendment right to the free exercise of his religion and to associate with members of a religion. These assertions were highly damaging, inflammatory, calculated to be inflammatory, prejudicial, and Worden was harmed by the state's actions. Not only did the state present the allegation against Worden during BW's testimony, the state emphasised both the racial and religious animus in direct, emphatic ways during closing statements, including by shouting and pointing at Worden during the relevant portion of the argument. The state's case against Worden was exceptionally weak, unsupported by any contemporaneous outcry or by any physical evidence. The allegation pitted that BW's credibility, whose story changed not only prior to trial but also during her testimony before the jury, and whose allegations were contradicted by several witnesses, versus the perceived credibility of Worden. The state manoeuvred through this weakness by presenting that Worden was racist towards black individuals, an attempt to make him seem morally reprehensible, particularly when the dynamics of the accusation and audience were considered. The accusation coming from a black prosecutor and to a jury containing 4 black citizens. This type of attack is impermissible and demonising. Harbouring racial animus towards others is seen as repugnant to our American ideals, and the presentation of this evidence and the way it was presented was only calculated at producing one result: make the jury find that Worden was a morally reprehensible person, so that they would find a way to believe BW's contradicted and inconsistent testimony. Worden requests this court find that the state violated the First and 14th Amendments by introducing racial and religious animus and stereotyping into the trial, violating Worden's right to freedom of association and the free exercise of religion, and his right to due process of law, and find that he was harmed as a result of the state's actions, and that it cannot be determined beyond a reasonable doubt that the error did not contribute to the conviction. 10. Trial counsel's failure to object to the prosecutor's injection of racial and religious animus into the trial constituted ineffective assistance of counsel. Trial counsel's failure to object to the prosecutor's injection of unnoticed and inadmissible racial and religious animus into the trial constituted ineffective assistance of trial counsel and violated Worden's right to the effective assistance of counsel under the 6th and 14th Amendments to the US Constitution. For purposes of brevity, Worden incorporates his earlier discussion regarding the discussion of the Strickland standard for ineffective assistance of counsel from Section 3 and addresses the deficient performance and prejudice prongs. Deficient performance. As outlined in Section 9 and incorporated herein for all purposes, the state presented evidence of alleged racial and religious animus and stereotyping was categorically inadmissible under the First and 14th Amendments pursuant to Dawson and its progeny reference. Additionally, this evidence constituted unnoticed extraneous bad acts, and trial counsel had a duty to object and keep this evidence and argument out of the trial. Further evidence. Recognising this duty and holding trial counsel ineffective for failing to object to inadmissible extraneous evidence. Further reference. Holding that trial counsel was deficient for failing to object to inadmissible extraneous offences in the PSI report. Trial counsel recognises he failed to lodge any objection to the relevant testimony portions of the racial animus testimony, and trial counsel failed again to object when the state offered this testimony during closing arguments. Had counsel objected, the trial court would have been required to keep this evidence of racial animus out. In addition, though trial counsel properly objected to the religion evidence that Worden was a Mormon seeking to marry his own daughter, trial counsel failed to object when the state emphatically argued this testimony during closing statements. Had counsel objected, the trial court would have been required to keep this inadmissible and unnoticed evidence of racial and religious animus out of the trial. The failure to object constituted deficient performance under the first prong of Strickland. Additionally, there can be no reasonable or constitutionally acceptable trial strategy for allowing such inadmissible evidence into trial, and trial counsel recognises it was not his intention or strategy to follow such evidence. Prejudice. As discussed in Section 9 and incorporated herein for all purposes, Worden was prejudiced by trial counsel's failure to object, as trial counsel's affidavit makes clear. State's injection of unnoticed and inadmissible allegations that Warden was racist and refused to let his wife stay in their home because she was pregnant with a black child, and that Warden was a Mormon and was trying to get the complainant to convert to Mormonism so that he could marry her, was highly damaging, inflammatory, calculated to be inflammatory, prejudicial. Not only did the state present these allegations during the testimony portions of the trial, the state emphasised this testimony in a direct, emphatic way in their closing statements, including by shouting and pointing at Warden during the relevant portions of argument. The state used this evidence to establish Warden was a morally reprehensible person so that they would find a way to believe the contradicted and inconsistent testimony of the complainant. This evidence was offered only to attack his character, make him seem repugnant, and offer no value to the issues in trial. Trial counsel's deficient performance prejudiced Warden as his confidence in this verdict was undermined, and there is a reasonable probability that the result of this proceeding would have been different but for that deficient performance that allowed the trial to be injected with highly inflammatory and damaging character evidence offered to demonstrate that Warden was morally reprehensible. Warden requests this court find that he was deprived of his right to the effective assistance of counsel under the 6th Amendment to the US Constitution, applicable to the state through the 14th Amendment, and grant him any and all relief to which he may be entitled, including a new trial. 11. Cumulative harm. Warden requests that this court find that the cumulative effect of the errors in this case be considered, and that this court find that he was deprived of a fundamentally fair trial, violating his right to due process of law. A number of errors, even if harmless when separately considered, may be harmful in their cumulative effect, and there's a reference. This doctrine provides relief only if the cumulative effect rendered the phase of the trial fundamentally unfair. Warden asserts that the cumulative effect of errors in this case rendered his trial fundamentally unfair and thus violating his right to due process. As discussed in sections 1 to 3 and incorporated herein, Warden was harmed by the state's introduction of and his trial counsel's potential opening the door to harmful and prejudicial extraneous offence and bad act evidence that was no more than propensity evidence against Warden, as it was not similar to the charged offence, did not fit within the open door, and did not rebut defence counsel's opening statement, brackets the purpose for which the trial court admitted the extraneous bad act testimony. As discussed in section 5, 7 to 8, and incorporated herein, Warden was additionally harmed by the numerous outside influences which plagued his jury trial and the jury itself, including members of the audience following jurors to their cars, communicating with jurors outside the courtroom, shouting that he was a rapist and a sex offender within earshot of the jury. The trial court commented on the weight of the evidence by telling the jury that they had heard about 25 years of a dysfunctional family at best during deliberations. Finally, and as discussed in sections 4, 9 to 10, and incorporated herein, Warden was harmed by the state's introduction of impermissible expert and bolstering testimony through child sex assault Detective Reed, who opined that BW was truthful, and by the state's introduction of and trial counsel's failure to object to evidence injecting racial and religious animus into the trial. These errors all had the effect of diminishing Warden before the jury and striking at his credibility and the presumption of his innocence. This court should find that his trial was fundamentally unfair and find cumulative harm in his case, vacate Warden's conviction, and grant any and all further relief to which he may be entitled. Prayer. Warden respectfully requests that this court find that he has established the grounds of error presented above, and that his conviction was obtained in violation of the US and Texas constitutions and the laws and applicable rules of the state of Texas. Warden requests that this court reverse his conviction, set aside his sentence, and remand this case to the trial court for a new trial or new hearing on his motion for a new trial. Warden prays for any and all relief to which he may be entitled in law or in equity. And that was submitted. The court has noticed that the appellant's brief has been received and filed on Monday the 28th of August in the above reference caused. The state's brief is due on or before Wednesday 27, 2023, and oral arguments have been requested. I'm not sure if I'm going to do the first part of the appeal brief because it just goes through the trial Maybe if you want me to, you'll put in comments. Otherwise, I'll leave it at that. Thanks for watching.